Good afternoon. My name is Matt Robbie, and on behalf of Christian Brother Services, I would like to welcome you to our Spring 2019 webinar series. Over the next several weeks, our webinars will explore contract analysis, cybersecurity, Medicare, plan giving, and other topics. For a full listing of all the webinars and their dates, please visit cbservices.org/webinars.php. Today's webinar is the fourth webinar in our series entitled Finance Office Best Practices: How to Optimize Benefit Eligibility for Religious. Before we get started, I would like to cover a few housekeeping items. Please note, audio will stream through your computer, so please make sure your speaker volume is up and at an audible level and your flash player is enabled. A copy of today's presentation can be found by clicking on the light green icon with a piece of paper on it at the bottom of the screen. You'll then be able to download the presentation. We will be using a lecture format today for this webinar. Our presenter will answer your questions at the end of the presentation. However, at any time during the webinar, you can type your question into the question box, which can be found to the left side of the presentation window on your screen. If your question box is not already opened, you can open it by clicking on the purple Q&A icon at the bottom of the page. Just type your question in the box and hit submit. At the end of the presentation, please take a moment to fill out a survey in regards to today's webinar and speaker. This survey can actually be found to the right-hand side of your screen. It is only a brief 5-question survey, and by completing the survey, you are not only providing us and the presenter with valuable feedback on today's webinar topic, but you'll also be given the opportunity to enter a drawing for a $100 gift card at the end of our webinar series. Now, before we get started, let us remember that we are in the holy presence of God. Creator God, through your world and the people that surround us, we pray that we may grow more aware this day of your life-giving presence. Open our minds and hearts to apply the knowledge from today's webinar for the good of all. We ask these things through Jesus' name. Amen. Thank you. Let me introduce our presenter. Constance Neeson is the Director of Benefit Eligibility Management for Religious for BMT, a division of Christian Brother Services. Constance is a licensed social worker in the state of Indiana. Constance and her team of benefit eligibility consultants specialize in implementing efficient benefit eligibility management programs for over 70 religious institutions. Over the past 13 years, her team has assisted various religious institutes in achieving a total estimated financial impact of over $100 million in increased income and in health care savings for their congregations through the use of various available benefit programs. The team also assists congregations with accessing enrollment into various insurance programs and with medical billing processing. Constance has been a featured speaker at previous conferences of the Resource Center for Religious Institutes, National Association for Treasurers of Religious Institutes, and Orientation to Management for Religious Institutes, and at Regional Congress for Religious Treasurers court meetings. Please welcome Constance Neeson.
Thank you so much, and good afternoon, everyone. I'm so pleased to be here with you today, and pleased to be asked to be a presenter here at this webinar. I have to let you all know that I am recovering from a bad cold and a cough, so I apologize ahead of time if I cough in your ears. I'm really sorry if I do that, but I have taken my cough medicine, so hopefully that will not happen. So as we begin today, I'd like to start by saying that in my experience, many of our religious institutes find benefit in assisting their members to access all the available array of benefit programs. And there are ways that if you are working in the finance office of a religious institute, you can enhance the possibilities for eligibility by your finance office practices. And that's what I'd like to discuss today. So this talk will be designed for individuals who are in leadership, for treasurers, for finance office staff, and for benefit eligibility coordinators, individuals who fill those roles for the various congregations throughout the country, and to be able to implement policies and practices that you will find helpful so that if you're applying for eligibility for your members for various programs, that will flow more smoothly. Today we're going to discuss a brief overview of what those programs are. I'm aware that at times when people participate in these webinars, they may be fairly new to the whole issue of government benefit eligibility. So we'll do just a brief overview of those programs. Then I wish to talk about how you can implement policies about managing the income of members and the assets of the members. Also want to address a little bit about patrimony and congregational support for the members. And then we'll discuss briefly records retention and database management. And I want to say that although this webinar is scheduled to be an hour, I'm very willing to stay on after that hour if there are questions that people would like to have answered. So if individuals feel like they need to leave at the end of the hour, I certainly understand that. But for those who might want to stay around and ask some questions, I'm very happy to provide answers if I can. So briefly, looking at the benefit eligibility array of programs that we look at, most of these programs are funded through the Social Security Act of 1935. In that act, there are 21 titles, but we mainly deal with 4 titles of the Social Security Act for members of religious congregations. That would be Title II, which is Social Security Income. We also call that RSDI, Retired Survivor and Disability Insurance. Title 16, which is Supplemental Security Income, or SSI. Title 18, which is the Medicare program, and there are several parts to Medicare, A, B, C, and D. And then Medicaid, which is Title 19. This grid I often use in my presentations defines those 4 primary title areas. Social Security and SSI are income programs, so I've colored them green on this slide. Medicare and Medicaid are insurance coverages that pay medical bills, so I've colored them blue. Again, Social Security and SSI, we access those programs through the Social Security Administration. Medicare, we also access through the Center for Medicare and Medicaid Services, and Medicaid programs are accessed through the various local, state, or county offices. The grid you're seeing now, which is the a table of the various benefits that are available, again, illustrates that Social Security and SSI are income programs. Medicare Part A is hospital coverage. Medicare Part B is major medical coverage. Medicare D is prescription coverage. And we know that Medicare doesn't pay everything. So there are gaps in the Medicare, and we need something to fill in the remainder amounts that Medicare doesn't cover. And the programs that primarily can help to fill in the gaps of the parts of coverage that Medicare doesn't cover, those 2 programs would be Medicaid, or the Qualified Medicare Beneficiary Program, QMB. Both of those programs can act as a Medicare supplement for an individual, so that with Medicare and Medicaid, or Medicare and QMB, that presents a pretty complete picture of coverage for all your healthcare needs. There also is the program SLMB, Specified Low Income Medicare Beneficiary. All that program does is pay your Part B premium, and it does help fill in the gaps of Medicare D, as do QMB and Medicaid. And then the last program we look at quite frequently is the Low Income Subsidy Program, or the Extra Help Program, which helps fill in the gaps of Medicare D. There is a program that we tend not to use very often called the Qualified Individual Program. It pays the Part B premium for individuals who qualify, but this is the one program that if one were to participate, it might keep someone else from participating, because each state only gets a block of money to cover the QI1 eligibility for the year. So we find that most religious would tell us, I don't want to enroll in a program if it would keep someone else from participating. So in our office, we tend not to use the QI-1 program in most states. So that's the array of programs we're talking about today primarily. There are a few ancillary programs, some state prescription drug programs that we also can use, but these are the primary programs that can yield financial impact to the good of the congregation. So when we talk about enrolling in the various programs, this is the primary array of benefits we're looking at. So when we talk about the income of various individuals, what do we mean by that? When we enroll in most of these programs, there is an income threshold, and the person's income must be below that amount in order to qualify. There's also an asset limit to most of these programs. So for income, there are a number of kinds of income we look at for benefit eligibility. That would include earned income, which can be a taxable salary. It can be self-employment. Also, for members of religious orders, they can earn income from their ministry in the Catholic Church. That income is paid directly to the religious order, and no W-2 form is generated. We call that income in my office stipend income. And that is another kind of income we have to look at for benefit eligibility for certain programs. There's also a kind of income called unearned income. That's your Social Security, your SSI, pensions, or annuities that would come monthly to an individual in their name. We also look at gifts of money. If gifts of money are predictable and regular, so we're not talking about your birthday gift or your jubilee that happens every 10 years. We're talking about if a person is getting a gift of money from a friend or relative every month or every quarter, and it's predictable and regular, then we have to also include that money when we're reporting income for the individual. And finally, sometimes, depending on how the congregation conducts their business, if the congregation is giving money to one of the members for their living expenses, depending on how that's done, that personal support money from the congregation can count as income to the individual. So if you're the person helping individuals in your congregation apply for benefits, you have to know how all of these income amounts are received and in which programs they may count. For Social Security and for SSI, the best practice, and I find that most congregations do this, is to have a separate bank account. It can be a checking or a savings account, but every month all the members, their Social Security is deposited into that account or their SSI. This is not your operating fund. It's a separate account, but once a month you sweep the money out of that specified deposit account into your operating account. And the reason we do that is that if that money is left there to accumulate over time, then when it comes time to review SSI, any money that has accumulated in that account can be divided up and allocated to each SSI recipient. So leaving money just sit in that specified deposit account can prevent SSI eligibility. So you always want to sweep that money out at least once a month. If you sweep it more often than that, that's fine, but at least once a month. Also, I just want to mention that we always recommend that members of religious congregations, unless they have a taxable job, are best advised to take out their Social Security income at age 62 versus waiting till 65 or 66 or some other age. We always recommend that because with time value of money and with the fact that you're receiving this money at the earliest possible moment, it maximizes the impact that money can have in your religious congregation. The only exception to that rule, again, is if individuals have taxable income from a regular secular taxable job. Those individuals can't draw out their money usually at age 62. They have to wait till they reach full retirement age. Currently, full retirement age is age 66. So again, when we talk about earned income, For most religious, there are a few religious who receive taxable income. They work in a secular job. They have a W-2 every year. They have FICA withheld from that job. If they have taxable income, that is always countable for all benefit programs. But for most religious, we find that they work in a ministry within the Catholic Church, whether that's a Catholic parish, diocese, Catholic school, Catholic hospital. That income is paid from that ministry directly to the religious order. However, the programs SSI and the low-income subsidy have specifically spelled out in their law that that money, even though it's paid directly to the religious order, is countable for those two programs, for SSI and for the low-income subsidy. So if you have a person who's applying for SSI or applying for the low-income subsidy, and if they work in a ministry, you have to factor in that ministry income as part of their reportable income for eligibility. For the low-income subsidy program, they will ask for the annual total amount. For SSI, they want you to give the monthly amount, dividing that annual total divided by 12, and give them the monthly amount. It's important, if you're the person enrolling people into benefits, to understand how income counts when you're reporting it. Now, you're going to report that whole amount, but in your mind, you have to be able to do the math of how will that income affect eligibility. If you're reporting unearned income, like a pension or the Social Security amount, that is going to count at 100% of its value. But if you're reporting earned income, whether it's the taxable or the non-taxable types of income, if you're reporting that income, it does not count at its full value when the government benefit office does the math. What they calculate is using this formula, the monthly amount minus $65 divided by 2, that's what they will count. You still report the full amount as their income, but you have to know in your mind that they will not count the full amount when they do their math. For the low-income subsidy program, because they do the annual total, that annual total minus $780 divided by 2 is what they will count towards that annual amount. Why is it $780? Because that's 12 times 65, and 65 is the what we call disregard amount. So again, if you're the person helping do enrollments, before you even do the enrollment, you can do the math for the individual so you know in your mind, are they even going to qualify? And then when you report all their income, you'll have the outcome that you are expecting. The other thing I always like to talk about income, again, is if you're the person doing the application or assisting the members to do applications, you need to know what income types count for what programs. For Social Security, we always report when we're enrolling in Social Security, what is the taxable income? And that can be either at a taxable job or it can be the fair market value that you are reporting when you're paying FICA for your members. For SSI and the low-income subsidy, they're going to count taxable income. They're going to count that non-taxable stipend income. They're going to count unearned income and predictable gifts of money. But for Medicaid, QMB and SLMB, they'll count taxable income, but almost universally they do not count that stipend income. So if you have a member who's working in a parish, working in a diocese, they may not be able to get SSI or the low-income subsidy, but they may be able to get Medicaid, QMB, or SLMB. You have to do the math, but most programs will not count that non-taxable money from their ministry. This is another chart I have where I talk about the various different kinds of programs and what counts and what doesn't. If you'd like more information about this, send me an email and I'd be glad to send you a full-size copy of this chart so you could put that on your wall and know which kinds of income count for which programs. So best practices for the finance office. would be for your Social Security and SSI, make sure those are being deposited to your central, separately dedicated account just for Social Security and SSI deposits. And then once a month, you sweep that money out of that account into your operating account. Make sure when you're getting ready to apply for benefits for someone, you do your due diligence and interview that member. Do not assume that they have no other income, and especially if they get regular gifts of money from family or friends. That has to be reported. Know the rules of each program and know how congregations support will affect eligibility. We're going to talk about that in a minute in more detail. Do the math in your head so that you know what outcome you're going to expect through that enrollment. And I have to say, when I do consulting with a number of religious congregations, the income piece of the puzzle is mostly very well managed. The part of the puzzle that is less well known in finance offices is the asset picture for the members. By assets, which we also sometimes call resources, we mean the financial or monetary property of the individual, or it can be real estate property of the individual. And the individual can own it all on their own, just in their name, or they can co-own those assets with someone else. That can be a relative or a friend or another member of the religious congregation, but those assets are in that person's name. So what are we talking about when we talk about assets? Well, bank accounts, life insurance, cash surrender value, savings bonds, stocks, real estate, vehicles and trusts, cash in their possession, and any other liquidatable resource. So we have to look at, and again, do your due diligence to ask, does this member own any of these types of assets? Now, if there's a congregational account owned by the religious order and the person's name is not on the account, but they are just a signatory, that does not count as their owned asset. So we're not talking about being a signatory, but we're talking about ownership. So it's okay for people to have assets. That's fine. Of course, we have vows of poverty, and so whether that's okay with your religious superior is another question. But legally, it's okay for people to have assets, but it's the total of all the assets combined that we have to be concerned about. So again, do your due diligence and interview the members before you attempt an enrollment to make sure in your mind you believe they are eligible. For congregational accounts, best practice is that if a member is going to be a signatory, that's fine, but try not to have the name of the member on the account or on the checks of the account. That way they are just being a signatory, and it's clear that that person is not the owner of the money in that account. I do occasionally run into situations where the accounts are structured that the name of the member is on the account. And if that's the case, then our advice would be try to transfer into that account the minimal amount possible each month and keep the balances low in those accounts. That would encourage eligibility for these various programs. We do encounter, and I've encountered this a number of times, certain congregations that encourage members to each have a bank account, and they tend to call these convenience accounts, or they may use another term, but they encourage members to have each of them a small bank account so they can cash checks. And often they will encourage that the primary owner get another member of the congregation to be a co-owner on that account. Again, that's perfectly fine. It's best to keep those balances low. The one problem I've run into with those kinds of convenience accounts is that sometimes one certain very dependable member will be selected by a lot of people to be their co-owner, which is all well and good, but when that very dependable member goes to apply for benefits, all those accounts that they are co-owners of count against their eligibility. So keep that in mind as you are asking people to be co-owners on accounts. If your practice is to have convenience accounts, not to have one person assume too much of that role of being the co-owner on too many accounts, because it'll work against that person. One of the practices that we find sometimes when I'm doing consulting with congregations is some orders will have yet another dedicated account where they will say to members, if you have money you receive for Jubilee, or if you have money from your allowance and it has accumulated over time, we will hold that for you in this special bank account. So you can give that to us, and then anytime you want it, though, you can ask for it and we'll give it back. Now, I'm not talking about patrimony here. I'm talking about other money the members have that they've received, and they just want to hold it for a future trip or for some other reason, and the order will be holding that money for the member. And again, there's nothing wrong with that, but that money is available to those members anytime they ask for it, and that money must be reported as the asset of that individual if you're going to enroll in benefits. So please be aware, it's no different than if I have a brother and he says to me, hey Connie, would you hold $3,000 for me? And he gives me his money and I put it in my bank account. But if he were to go and apply for Medicaid, and if he did not report that as his asset, he would be guilty of fraud. And if I'm aware of it and I'm holding his money, I'm guilty of conspiracy to commit fraud. And both of us could be prosecuted for that. So hiding money from the government is never allowed. So if you're holding available money for someone else, that money must be reported as the asset of that individual if you're applying for SSI, Medicaid, QMB, any of those programs. So it's fine to do that. It keeps that money safe, but just know that that money must be reported. The other issue we run into in the area of assets is that occasionally a family member in their will before they die creates a trust, and one of the members of the religious congregation is beneficiary of that trust. As the finance office, what you can do if you're aware of that situation is seek a copy of the trust document, just so you can verify, is that trust going to be countable as an asset if we ever want to enroll that person in benefits. Most trusts are available because most trusts have a provision that the trustee has the ability to distribute money for the needs of that person. So if there is a trust fund existing for one of your members, the best thing you can do is find out how will that trust fund affect eligibility for that member. Another thing that you can do as finance office staff is to educate your members about their decisions. Members are going to make lots of different decisions in their life, and they need to be aware of the consequences of those decisions. I'm not saying they should or should not make those decisions, but they need to be aware of the consequences. So if they're going to put their name on their cousin's bank account, what is the repercussion of that? And rather than putting their name on, could they put their name on as POD, which is property at death? So that person, the primary owner, continues to maintain ownership of that account, and only on death will that money go to that member of the religious order. So payable on death is a good way to set up an account so that it doesn't count against that member of the order for most of the time of that account, only at the death of the primary owner. The same things if they're going to take out savings bonds, if they're going to own stocks, if they're going to have real estate, if they're going to accumulate cash in their name. All of those actions have consequences for eligibility. And that's okay, but they need to know how they are influencing the whole congregation by their decisions. So having that kind of educational meeting can be very helpful. I do want to just talk briefly about transferring assets. I get a lot of questions about this every year. Certain people have money, and then they want to give that money away either to a family member or to the congregation, and then they apply for SSI or Medicaid, and the caseworker says, have you given away any assets in the last 5 years? And if the answer is yes, we call that the look-back period, then the money that you gave away invokes a penalty in SSI or Medicaid. And especially for Medicaid, the penalty can prevent Medicaid from paying for nursing home care or in-home health care. So when it comes time for a person who has a lot of money in their possession to make that decision, how does that affect their eligibility is a big question. The length of the penalty that they will have to serve when Medicaid or SSI won't be available to them is determined by the total that they give away divided by, for Medicaid, the state average of 1 month of nursing home care. For SSI, they divide it by 1 month's worth of SSI eligibility. And that yields the number of months of the penalty. And I will say that just because there's a 5-year look-back period, if you give away a significant enough amount of money, your penalty could be 10 years. So that the 5 years doesn't mean that's the longest your penalty can be. That's just the length of time they look back. But the penalty can be quite significant if you give away a lot of money. In some states, the penalty begins the month you give away the money, and then during that penalty period, Medicaid is not available for long-term care. But in more and more states, they've changed their law that the penalty begins the month you apply for Medicaid. So if you gave away money 4 years ago, but today you apply for Medicaid, that's the day the clock starts ticking for the penalty period. So one of the things that's important to know if you're in the finance office is what is our state rule about that, and what are the rules of the other states where we have members living? Because we know quite often congregations have members who live in multiple states. So it would be helpful to know what the practices are around penalties. And I will say that if someone gives away money, there are 3 ways that we have found that you can try to rebut that penalty. One way is to argue, well, yes, this person gave away patrimony assets, but they couldn't have used those patrimony assets for their own care anyway. It was unavailable to them. Sometimes that argument has worked. Another thing is to say, yes, that person gave away patrimony to the congregation, but it really was for the purpose of repaying the care they received over the many years of being a religious. And if all else fails and you cannot rebut the penalty period, but you need them to have their Medicaid eligibility for long-term care, then you can reverse that renunciation back to the person so that deletes the penalty. So if penalty issues arise for your congregation, it's best to do some strategizing and brainstorming about, on a case-by-case basis, what's the best way to resolve this transfer of asset penalty for our members. The thing about SSI and its penalty for transfer of assets is that if the congregation is the recipient of that renunciation of money, and if the renunciation was due to the vow of poverty, then SSI's penalty can be erased. So that's a good quotation to know in the program operation manual. If you have an SSI transfer of asset penalty and if the money was renounced to the order, then there is this one specific law that can erase that transfer penalty. That won't work, however, if they gave the money to a family member or somebody else. So best practices around assets. Educate the members. That I can't stress that enough, so that they know what their decisions, what those consequences will be. Structure your congregational accounts so that they're not countable to the individual. And I would strongly recommend that you contact members around the age of 60 to find out if there are any financial issues that are going to be a future impediment to eligibility, because that gives you time to work out solutions to those problems. If you wait till they're 75 or 80 and suddenly you have this financial problem, it may be like too late to really fix it in a constructive way. So addressing these issues at a younger age is good advice. I'd like to address patrimony just briefly. Patrimony is not countable as an asset if, and the if is, of course, patrimony is the money one brings into religious life and sets aside, or the money one inherits while under vowed life, and that money should never, never be used for personal use while the person is in religious life, in their vowed life. They should never, never, never use that money. So if we can prove that that money is held in such a way that it is unavailable to the person for their own personal use, then it's in the government's regulations that that patrimonial asset should then not count against the person as an asset, nor the annual income if we can prove that they have no access to that annual income. So the best practice for leadership is make sure your policies for all of your members are clear, that you as leadership will never give people use of that money unless they're leaving their vowed life, and that benefit coordinators make sure you're clear on the policy of your congregation. And if a person elects, which canon law allows this, that a family member or a friend is managing their patrimony, you need to know that, because it's more difficult to prove that that money then is unavailable. So as the benefit coordinator, you need to be clear on the practice of every member of the congregation. If they are allowed to retain patrimony, where is their patrimony being managed, and is it available or is it unavailable? Regarding congregational support, most congregations give their members a monthly allowance. They sometimes call it their personal budget or their personal money or their stipend or their allowance, but it's an amount of money for them to be able to buy their personal needs. And if that amount is less than the total of all their other income, then that money is not countable. So if you have, let's say, a sister, priest, or brother who gets $500 a month in Social Security, that money goes to the order, and then that person gets $100 a month as an allowance. It's just like you've given them back a part of the Social Security that they had deposited. So that $100 does not count. On the other hand, if the amount you're giving them exceeds all the other income we're reporting on their behalf, then that excess amount of money is reportable. So in this example, you have someone who has $200 a month in Social Security and $100 in a pension, but the order gives this person $500 a month in allowance. That excess $200 has to be reported as a gift of income, predictable and regular, to this individual. So again, when you're managing enrollments and looking at eligibility, you need to look at your practices. You need to look at each person's, the math of their situation, to see if there's any part of their distribution of personal money for their support that is in excess of what you're reporting otherwise on their application. We most often see this as a problem when there's an individual living in an apartment on his or her own, and the congregation is sending money to that member to pay their rent and utilities. So for example, if a congregation sends $2,100 a month for all the living expenses, and that member has $600 a month in Social Security and a $200 a month pension, so $800 a month, the excess amount in this illustration is $1,300 a month. That has to be reported as income for that individual, and that's going to make that person not eligible. So we would recommend that the finance office, rather than sending that $2,100 a month, would get the name and address and amount of the rent and send a rent check every month directly to the landlord, get those utility bills, send a check directly to the electric company and the gas company and whoever else every month, and only send the member a minimal amount that's needed for their groceries or personal items, or even better, have the member use a charge card. Charge cards do not count as assets for all their food and gas and all that, and in a credit card owned by the order. any of those options will deplete the amount of money being sent to that member, and if it's less than the rest of that income that we're already reporting, then that won't count against them for eligibility. Regarding records retention, I get questions about this quite often. How long should we keep our paperwork, and what should we keep? I will say that there is a lot of paperwork that accumulates. In our office, we have like 57 4-drawer filing cabinets full of paperwork for all of our client congregations. So I get it. There's a lot of paperwork. There are certain documents that you should retain permanently. And you can retain the original or a good copy, and that would include the birth or baptismal certificate, copies of the Social Security card or the original, picture IDs, passports, naturalization papers, and original application paperwork and award letters. So the first time you apply for Medicaid, the first time you apply for Social Security, SSI, etc. Those original applications you should keep. There is other paperwork we know that accumulates all the time, and you can either scan those documents and then shred the originals once you know that it's securely saved, or retain those documents for 3 years and then shred them. So that's that annual letter you get every January. Here's your new Social Security amount. Here's your new SSI amount. Here's your redetermination for Medicaid. Here are your explanation of benefit letters from Medicare and from other insurance. We recommend you keep those for 3 years and then shred. Or, as I say, if you scan them and save them as PDFs, that's fine as well. You just want to make sure that if you're scanning and saving, that you have a good backup system so that if your computer crashes, you're not going to lose all of that verification documentation. And I will say we always recommend have a central mailing address so that you're getting all of that government benefit paperwork so that you can keep it. We like using P.O. boxes if there's a problem with how the mail is distributed. I know sometimes, the members of the congregation, sister, whoever, is picking up the mail and distributing it. You want to make sure they know that the finance office needs to get the copies first so that you can keep those documents the length of time you need to. It's important, in fact, it's mandatory, that before you act on behalf of one of the members of the order, you must have their signatures on certain authorization forms. Just being hired by the order, just being in an office as a superior or a treasurer does not give you any authority to act on someone's behalf. You must have signed authorized representative forms. One of the most important forms to have is the Social Security 1696 form. This is a really, really primary document. If you're working on behalf of members of an order, every member you work on behalf of should have signed one of these for you. And we always add a little text box on our 1696s that specify according to, there's a law called GN 03910.060-A5 that says that the person giving you their authority can decide how long that authority lasts. And we want our authority to be ongoing until the person tells us it's canceled. So we add this little box that this authorization is ongoing and indefinite. Another document that's really a primary document to have is the Social Security 3288 form. There's a whole array. I think when we have individuals sign documents for us, there's like 14 pages of permission forms from Social Security, Medicare, Medicaid in the state where they live. We put together a whole packet so that we have their authorization. So again, if you're the person doing that benefit management, make sure that you have gotten all the appropriate signatures on those forms, or you may be conducting business illegally on behalf of that person. So make sure you get all the right signed authorizations. and you want to keep those forms as long as they're needed or until the government comes out with an updated form, because they do that every several years. The 1696, the 3288, all these other forms, they replace them every so many years. So when they replace them, guess what? You have to have new forms signed. So, and also the form needs to be in the name of an individual, not just I give my treasurer or I give my superior this permission. It has to be the name of an individual. One other document that is changing right now is the Medicare cards. New Medicare cards have been coming out this past year. Not everybody has them yet. Don't panic if you don't, because that's pretty normal that not everybody has their cards. I'm recommending that you keep a copy of the old card for 3 years after it expires. And so it expires next January of 2020. I would say just keep a copy of all those old cards in everybody's file until 2023. And then we'll be sure that we're beyond any window of needing those cards. But I would recommend that you keep a copy of those cards until then. Best practices, again, for record retention, be sure to protect the security of all these documents. If they have personally identifiable information on them, Social Security numbers, Medicaid claim numbers, all of those documents, never email any document that has a Social Security number on it or any of those claim numbers, because email is commonly intercepted. It is not secure. If you're going to scan documents and save them in PDF form, make sure you save them securely. If you're using the cloud, there are certain websites that are frequently hacked, like Dropbox. I would not recommend using Dropbox. Find a secure cloud-sourced place if that's where you're going to save your documents. And again, some documents are permanent, others are disposed after 3 years. And if you have someone who is your benefit coordinator and they leave that job, new forms all have to be signed. When agencies update forms again, you'll have to get new forms signed. And when you are disposing of documents, make sure they are securely shredded. And that's not just the long strips of shredding, but the cross-cut shredding that really makes it impossible to reassemble those documents. Database management. Let's just talk about that very briefly. It's really, really helpful to create a place where you're tracking all this information for the whole list of your members, whether that's using an Excel spreadsheet or an Access database spreadsheet. In our office, we have a web-based tool we call Beatrice, which is it's built on, if any of you are familiar with this, a program called MySQL, which is, again, sort of like an Excel or an Access table-based document, but you want to make sure you're tracking all the names and addresses and all the income and all the assets, the insurances and the claim numbers, and any other notes about that specific person and their eligibility. So I think it's really, really important that all of those documents and all the files you have, you cross-reference that into some easily accessible spreadsheet or, like I said, we use Beatrice in our office, some way that you can track down quickly what the eligibility is for benefits. And in closing, let me just say, it is important in the finance office, the practices you use, the policies you set in place, they can influence whether a member is eligible to enroll in these benefits. And if you find that your policies are not as facilitating to eligibility, then you can adjust those practices. You know, we've helped a lot of different congregations make changes to their policies so that it does make enrollment in these benefits easier, because in the long run, those enrollments yield very positive financial impact for the congregation. If you need advice or help about that, please reach out to me and our BMT, Benefit Eligibility Management. We're part of the CBS team now. So reach out to us if you need advice. And again, I always say let the Holy Spirit lead you in all of these benefit eligibility challenges. This is my contact information. The best way to reach me is through email. But I welcome people to reach out to me, and we're happy to assist with advice or with other information. And thanks to all of you for being a part of this wonderful webinar today. And I now will move on to questions and answers. And I believe you can type in questions in the Q&A list. And then if you type them in, the Romeoville staff are going to read me some of those questions.
Thank you, Constance. We'll now open the floor for questions. And as Constance just said, remember that you can ask your questions by typing in the question box, which can be found to the left of the presentation window, or just click the purple Q&A icon at the bottom of the screen, and then hit submit. Our first question: what are the consequences of not having a dedicated account for direct deposits for SS or SSI?
Okay. One consequence is if your Social Security and SSI are going directly into your operating fund, then the entire amount of that operating fund is considered the property of those Social Security and SSI recipients. So at redetermination time, when they ask for SSI especially, what is their asset, or if that person with Social Security applies for Medicaid, the entire amount in your operating fund is considered their asset. If it's, $500,000, divide that by 50 members getting deposits, then that would be each person's asset. So it is very, very important, I think, to have your operating fund very separate from your deposit fund. And what I would do, rather than creating a new deposit fund, I would create a new operating fund account, move all your money into that new account, and just retain whatever minimal amount you have to in that original fund, and let that become your deposit fund. But create a new operating fund, in the name of your congregation, and move all that money out would be my best advice.
Okay, thank you. Is there a specific amount a sister can keep in cash without affecting eligibility, such as Christmas cash that was given to her as a gift?
Oh, that's a really good question. And the answer is the amount each person can retain depends on the program into which they're enrolled. So for SSI, the maximum amount of all their assets added together is $2,000. So if that person only has cash and no other asset, the most asset or cash I would recommend they keep would be like $1,500 or $1,600, so that they're well below the $2,000 allowed amount. If they have a bank account plus cash, and the bank account has $1,000, now that reduces the amount of cash they can keep, if that makes sense, because it's the total of all of them added together that's important. On that original slide, let me see if I can get back to it. It's like a grid. I'm almost there. There we go. On that grid that shows all the different programs and their asset limits, the QMB and SLMB asset limit is higher than for most states, than the Medicaid or SSI asset limit. The low-income subsidy asset limit is even higher than that. So how much a person can retain will depend on what programs you are targeting for them as their eligibility, if that makes sense.
Perfect. Well, thank you. Our next question: if monthly support money is drawn by a congregational check for which the religious is a signer only, is that considered countable income?
That's a good question. It depends on what happens to that money once they cash that check. Does it go into that person's bank account? Does it go into a congregational account? Does that person have use of that money? There are a lot of variables, so I don't think I can say yes or no. What I would say to whoever asked that question is send me a direct email about that question, and let's talk more specifically about your practices and what happens to that money, because there are a lot of variables that can influence whether or not it's countable.
Perfect, thank you. And we'll share your email address once again at the end of the Q&A period, so people can jot down your email address as soon as we finish the Q&A section.
Okay.
Okay. Let me get to the next question here. Our local Social Security office tells us that we cannot use a central mailing address. Is that the individual must have the address where they are living? Is there a law we can cite that you mentioned?
There is a law about that, and basically the law says every beneficiary can use whatever address they want to use. So if your Social Security office is saying that, I would challenge them to show you the law in their book that mandates that they cannot use a mailing address. Because that is, they're going to have a hard time finding a law that says that, because that's not what the law says. They're making that up. So I would say, by all means, challenge that and ask that person to prove on their records where it says that. And if they do give you a law citation, please email me that, and let's strategize about how to rebut that, because that is the opposite of what the law says. The law says the beneficiary can use any address they want as their mailing address.
Perfect. That's very good information. Next question. Will a legal, durable power of attorney work in place of an authorization form for Social Security?
No. Most government agencies will not recognize powers of attorney. So that's good for persons. Powers of attorney can help when you go to the bank. There are certain scopes of power of attorney, but most of the time government agencies don't recognize powers of attorney. Once in a while we'll find one that will, but mostly they need their specific form designed for that specific agency signed. So like Medicare won't take Social Security's form, and Social Security won't take Medicaid's form. It has to be the form that has the language for each of those agencies. So power of attorney is really not a substitute. However, let me say this, legal guardianship is. So if someone is so incapacitated that you go to court and have a legal guardian appointed, that legal guardian is empowered to sign all documents on that person's behalf. So legal guardianship does move to the top of the line of recognized authority for who can sign documents, but POAs really are not very helpful.
Okay, our next question. If support money is sent to an individual to pay rent, etc., but the member is a signer only on the checking account, not the owner, does the excess have to be reported as income for that individual?
This is a similar question to the one that was before reported. Sometimes no. So if you're transferring money from one congregational account into a sub-account and that person is only a signatory, then sometimes no, that does not have to be reported. But before I would say that for sure, I would advise you to send me an email and let's talk more in detail. Because again, there are lots of variables about how people handle money.
Perfect. Our order has a pension plan for our members. Is it a good idea to have these deposits go into a separate account rather than our general operating account?
That's a good question. It depends on how the pension plan is structured and whether that pension income is the income of the individual versus the income of the order. So again, I would say send me an email and let's talk about this in more detail, because If the pension plan is structured that the money is the money of the individual, which I have encountered that in certain situations, then that money is going to have to be reported for that individual for benefit eligibility. And no matter which account it goes into, there are a lot of variables when pension plans are created. So I would want to have more detail before I could give you really good advice about that.
Okay, we have one more final question. We have one central checking account for all of our communities. The local treasurer is listed on the check address. Would it be best practice not to list the name of the sister on the check return address?
If it's possible, I always recommend never putting names of individuals on any bank account or any documents, because when that person goes to apply for benefits, will that person be influenced? Will the agency look at that as ownership by that member because their name is on the account somewhere? So if it's possible not to have a name of a person, that's always my best recommendation.
Perfect. Well, thank you, everyone, for your questions. And I know there were additional questions that were asked that we just don't have time for at the moment. And there are also some questions that were very specific to your individual congregations. We will make sure we get those questions specifically over to Constance so she can actually answer those questions individually for you in regards to your individual congregation specific questions. For additional or more specific questions like we just mentioned regarding benefit eligibility and how Christian Brother Services and BMT can assist you, please contact Constance by using the information on the screen in front of you. As Constance mentioned, the best way to reach her is through her email address, which can be found at the bottom of the slide. As a reminder, a downloadable copy of today's presentation can be found by clicking on the light green icon piece of paper at the bottom of your screen. You'll then be able to download the presentation. This was the 4th webinar in our 10 webinar series for the spring. Please join us next Thursday, March 14th, for our next webinar entitled Paddling Beside a Steamship, Finding Your Place and Pace in the 21st Century. This presentation will discuss ways to harness the power of human and technological tools to increase productivity and improve your life as a manager. To view or register for this or the rest of the webinars, or to view any webinars on demand, please visit our series page at cbservices.org/webinars.php. You can also visit the site to download past webinars from previous series. Once again, thank you to our speaker, Constance Neeson, and as always, thanks to all of you for attending today's webinar. God bless.